In this video, I am going to be explaining the role of the judge in a domestic violence criminal case, and some of this may surprise you. I know it surprised me when I first became an attorney. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be explaining the role of the judge in a domestic violence criminal case because it's somewhat counterintuitive. Now, if you've already been to court, or maybe you're imagining going to court for your domestic violence criminal case, it can feel really intimidating. You go into this courtroom, there's a judge who's higher up on the bench than everybody else. Sometimes they're nice, sometimes they're really grouchy. And maybe you're thinking, oh my gosh, I got a bad judge. That judge is terrible, I'm screwed. Or you may be thinking, I have a great judge. This is great for my case. But let's talk about how much the judge actually influences what happens in your criminal case. Okay, so the first thing that the judge is in charge of is setting your bond, aka bail. Not just the monetary amount, but also any conditions of your bond. At the first court date, let's say that your bond was set at $50,000. That's the typical felony domestic violence 273.5A bond. But there are really bad injuries in the case. And so when the prosecutor files the charges against you, they include a GBI, that's great bodily injury allegation. At the first court date, the prosecutor may ask to increase your bail. Now, increasing your bail means that you would either go into custody, go back into jail, even though you, through a bail bondsman, already paid $50,000, or you'd have to get a bail bondsman there really fast to post the additional amount. So what will happen in that case is the prosecutor will make his or her arguments to the judge. Your defense attorney will also make arguments to the judge. And the judge will have to decide, is your bond going to be increased or not? And this can happen throughout the case. Like, let's say that there is a protective order in place. You're not supposed to contact the victim. And there's an allegation that you do. Now there may be an additional charge, and the judge has to decide, do I just keep the bail the same, or do I increase it? Likewise, the judge can impose additional conditions on you as part of your bond. If it is a case involving alcohol, sometimes they'll make you go to Alcoholics Anonymous, or they'll make you wear a device on your ankle that monitors whether or not there's any alcohol in your system and make it a condition that you wear that and also that you don't consume any alcohol. Sometimes in domestic violence cases, they could order you to go to domestic violence classes. They could order you to go to anger management. Number 2, for domestic violence cases, at the very first court date, if charges are filed against you, and by the way, make sure that if you were arrested but you have not been to your first court date, you have an attorney trying to get the charges dropped before court. But assuming you go to your first court date and charges were filed against you, then the prosecution is always, in the state of California, going to ask for a protective order barring you from contacting the victim. Now, if you are broken up with the victim, if you don't care about talking to the victim anyway, then maybe that doesn't matter. But if the two of you are living together, if you have kids together, if this is going to be a big problem for you and you definitely want to be in contact with one another, then it's the judge that's going to make the decision. And I have other videos about this, but the only way that the judge can decide to not issue a protective order in that case is for the victim to actually be present at court and to request that the judge not issue the protective order. The victim will also have to say that they are not afraid of you and that if anything were to happen, if there were anything more than peaceful contact, they would call 911. I know that sounds counterintuitive, but that is by statute. And the prosecutor is going to, whether the victim wants the protective order or not, the prosecutor is going to read some of the facts from the police report, which is going to feel really bad for you as the defendant, but the judge has to assume those facts to be true. So that is not the time for you to contest those charges. The judge has to assume that they're true. And the judge has to listen to all that and make a decision. Are they going to issue the protective order or not? Are they going to allow you and the victim to be in contact or not? Third, the judge is going to be the person to rule on any motions that your attorney may file. For example, let's say that you made some statement that is incriminating. You made a statement that could be misinterpreted, that basically your attorney wishes that you hadn't said, and you were in custody and the police were questioning you, but you had not been read your Miranda rights. Well, then your attorney can file a motion to suppress the statement that you made. Suppress meaning that it gets thrown out. And the judge is going to have to look at the motion and make a decision. Number 4, providing an indicated sentence. Okay, what an indicated sentence means is that your attorney asks the judge, if my client were to just plead no contest to what they have been charged with, if they were basically to plead guilty, what would you, as the judge, give my client? Now, this is an option that your attorney might use if, for example, you're charged with a felony, something where you could be sentenced to prison, but you could also get probation. And the prosecution, despite your attorney's best efforts, is only willing to offer prison. Your attorney can then go to the judge and ask the judge, hey, if my client were to plead guilty to this, what would you give my client, and see if it's a better offer. And your attorney can sometimes go into chambers or approach the judge off the record and tell the judge all the good things about you and the reason why you should get probation. And then it's up to the judge. And let's say that your charge is a PC 273.5A and it's your second offense, or there were really bad injuries, and so the prosecution wants prison time. Well, your attorney can also ask the judge, in addition to asking for probation, your attorney can ask the judge to reduce the count to a misdemeanor. This is called a 17B motion, where the judge decides that based on the circumstances overall, this should actually be a misdemeanor and not a felony. Number 5. Agreeing or disagreeing with a plea deal. Okay, so your attorney and the DA are going to go back and forth, and ultimately they might come up with a deal that you want to accept. This might be a dismissal in exchange for classes. This might be probation. It depends on the case, right? But ultimately, let's say that you decide that you do want to accept this, that this is in your best interest. Well, it still has to get past the judge. Now, in most counties in California, the judge will just go along with whatever the parties come up with. I used to be in front of a judge when I was in Illinois and I was a law student. I was allowed to practice law under a real attorney's license. I was in front of a judge who would routinely reject, a misdemeanor court, would routinely reject our deals. So the judge is being harsher even than the prosecutors in the cases. Fortunately, that's not generally the case here. But sometimes the judge will question the deal if they think that it is too lenient. And it's up to your attorney and sometimes the DA to convince the judge or get in front of another judge that this is something that should be approved, that it is just, and that it is a good outcome. Judges in domestic violence cases and in criminal cases generally sometimes act as mediators, where they sit down with, or even in court, talk to the prosecution, talk to the defense, and try to get them to come to an agreement. Sometimes they'll say to the defense, your case is really bad. What are you going for here? And of course, they don't know the facts like the defense attorney knows, so hopefully the defense attorney knows what they're doing and isn't hearing anything new. And they'll also put pressure on the prosecution. They'll try to pressure both sides and see if they can make the case come to some agreement, because the alternative is that there's going to be a trial that is going to take up enormous resources of the court system. Number 7, for felony cases, there is a preliminary hearing, which is also called a probable cause hearing, that takes place at the end of the pretrial stage. So basically your attorney have tried to get a deal from the prosecution, the case has not settled, and now you go to this preliminary hearing where the prosecution has to show the judge that they have enough evidence to send the case to the trial court. Now, the prosecution has a very low burden to meet at this preliminary hearing. It's just probable cause. Probable cause is the same standard that they use to arrest someone. People get arrested for things that they didn't do all of the time. So it's a very, very low bar. But at the preliminary hearing, the judge is in charge of, first of all, how much leeway to give your defense attorney in asking questions of the witnesses. Some judges let us ask a lot of questions. Some of them really limit us. And in these probable cause hearings, I know that probably, no pun intended, in most cases, the judge is going to move the case onto the trial court. But this might be my only chance before trial to ask questions of the victim. So I want to nail them down to details. I want to ask them about things that they said to the police and see if their testimony matches here. Sometimes the judges don't really like that. That's not really supposed to be the purpose of a probable cause hearing, but of course, as the defense, you have to try to get as much of that in as possible if that's your only chance to question the victim before trial. The other thing that the judge is in charge of at the probable cause hearing is determining, is there probable cause? Is there enough evidence here? And the judge can also decide that some counts that are wobblers, something that could be charged as a felony or a misdemeanor. This is also an opportunity for the judge to reduce any felony charges that are wobblers to misdemeanors. Number 8, if there is going to be a trial, then the judge is in charge of ruling on any evidentiary issues. So the judge is in charge of deciding whether certain evidence can be admitted and basically how the trial is going to be conducted. Now, there are certain judges who super micromanage this, and it can be super annoying. There are judges who will say that things that are favorable to the defense that you really want to bring in. For example, in the context of domestic violence that after you were arrested, the victim kept texting you trying to get you back. I want to bring those in for my case, but there are some judges out there, I'm sure, that would tell me that I can't, and that can be potentially a big problem. Some judges also, and this may not mean as much to you as the defendant, as a defense attorney, it bothers me, or at least affects me. Sometimes they will really limit the questions that we can ask potential jurors. So I don't want to just ask the judge, do you have a bias against the police? Do you believe my client is guilty just because he's there accused of domestic violence? Those are stupid questions because we know what most people are going to answer, even if they do have a bias. Yes, there are a few that will raise their hand and say that they have a bias, but most people don't. And so I want to really dive in and ask as many questions as I can to try to get an idea of their mindset. Some judges also will limit how long our opening statements and closing arguments can be, which might not necessarily be a big deal as long as they tell us in advance, but that is something to keep in mind that the judge does have power over. Finally, number 9. In the event that you lose the trial, the judge is going to be in charge of sentencing you. So if you have a judge who is pretty fair, and this is a case where the prosecution has really overcharged you or has been overzealous, was only offering you prison time on, let's say, a PC 273.5A, it's a first time, well, it's possible that even if you lose at trial, the judge might give you probation anyway if you're eligible for probation, or the judge might throw the book at you and give you 4 years. That depends on the judge. So it's not like if you lose the trial, you automatically get the max. The judge will hear from both sides, from the defense and from the prosecution, good things about you, bad things about you, and have to make a decision. I hope that you found this video helpful. If you do have a domestic violence case in California and you need help with it, please feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find the video helpful, please don't forget to like, subscribe, and ring the bell.